Thank you, Chairman.
Thanks, Senator Whitehouse. Senator Cornyn.
Judge Kazin, I'm glad that the chairman asked you about your experience with naturalization ceremonies. My experience has been the same. It's one of the most positive, hopeful experiences that I've ever had, like you suggested, participating in that process. Of course, what we're talking about is legal immigration, which I think has been an important part of the lifeblood of our country, our culture, and our prosperity. Illegal immigration has been a disaster. You are going to be sitting as a Article III district judge in a border city, Laredo, Texas, right across the border, Nuevo Laredo, where when I was in college, we used to go over to dine and shop and things like that. No one goes to Nuevo Laredo anymore because of the violence and the kidnappings and the like. But can you just describe a little bit of the changes that you've seen in Laredo, a border city in Texas, over the last few years when it comes in terms of the volume of migrants, the drugs, and the violence?
Senator, of course, I've grown up and lived along the border my entire life. I raised my daughter in Laredo, Texas, and so we're part of the community. Illegal immigration is a serious problem for the border communities and the nation in general. We see, of course, a heavy volume of immigration criminal cases in our courts. That makes up the majority of the cases that we deal with. I don't personally, honestly, in my day-to-day life living in Laredo, I haven't experienced a particular change as a result of the immigration issues and the illegal immigration, but certainly it is reflected in the volume of cases that we deal with. Even as a magistrate judge, I handle a lot of different pieces of those criminal cases, and it is a serious issue that we deal with.
Senator Whitehouse talked about the dearth of civil jury trials. Have the immigration docket in border courts like yours made it difficult to get to civil jury trials because of the volume of cases?
Historically, that is exactly correct. Traditionally over the years, it was my father as a judge. As we know, we have deadlines to resolve civil cases, and so it's been what we say at the courthouse is the criminal docket is a jealous mistress, and it is difficult to focus attention on the civil docket seriously because of the heavy criminal docket that we have along the border. And so one of the things I was told by my district judges that I was hired to do as a magistrate judge was to focus attention, because of my background experience with civil litigation, was to focus attention on the civil docket and try and get civil cases to trial if the parties consented to me.
Of course, there's probably no bigger impediment to access to the courts in a civil case than the cost of hiring counsel and the time it takes. And in fact, if you look at the statistics, I think one of the reasons why there's so few civil jury trials these days is because the cost of litigation. And I worry that more than anything else, that we've priced access to justice in a civil case out of the price range for most litigants, unless, of course, you happen to be catastrophically injured and are able to negotiate a contingent fee with the lawyer representing you, or perhaps you're hired by an insurance company or some Fortune 500 company. But that's a huge concern of mine, not something you all can necessarily solve, but I think it's a huge problem for our country in terms of access to justice. You might as well put the lock on the front door of the courthouse for many people, because they just can't afford to get there or the time it takes to get their case resolved. Judge Kusabai, if I'm pronouncing that correctly, let me just ask you, Senator Graham asked you about some comments in a Oregon State Bar Bulletin, I believe, entitled, "Is There a Place for Us?" You stated that we must set aside conventional ideas of proof when we're dealing with the interpersonal work of equity, diversity, and inclusion. And in that same interview, you said, as a judge, I can appreciate the challenge of employing a different mode for understanding truth. Could you explain what you meant by those words?
Yes, Senator. First, I'd like to explain that in the course of all of the time that I've served on the courts, that the rules of evidence, the burdens of proof, the standards that have been established by the law and precedent have always been that which I have followed and upheld.
Well, that's reassuring, but you can understand why I would ask a question about different modes for understanding the truth and setting aside conventional ideas of proof. Are you talking about in the courtroom or outside of the courtroom?
Absolutely not in the courtroom. What I was referring to was the idea of sitting down and talking with a friend from a different background. And when that friend from a different background might explain an experience, to be able to simply set aside the idea of saying, well, prove it to me, but simply accept that that was that friend's experience, to understand where that friend was coming from. So oftentimes lawyers could be accused of always trying a case, no matter who they might be talking to, including friends. And so the idea of setting that normal skill and technique aside when talking with somebody, whether it be at a coffee shop or even in a meeting, to be able to look at each other with dignity and understand that people have different experiences.
Thank you. My time's up.
Thanks, Senator Cornyn. Senator Blumenthal.